Hello, and welcome to this news event. Today, you'll be hearing from 4 speakers and a moderator, and then we'll open the floor for questions in the Q&A period. During the Q&A, we'll also be joined by 2 additional legal experts. The Q&A period will be for reporters only, and if you wish to ask a question, use the raise your hand function on your Zoom dashboard, and your line will be unmuted when it's your turn to ask a question. Please note that the news release related to today's event is being emailed to you now, and just in case, we're going to drop a link to the news release into the Zoom dashboard chat window so you can get to it. I'm going to turn it over to Barbara Roper, Director of Investor Protection, Consumer Federation of America, who will moderate the opening statements.
Thanks, Max, and thank you everyone for joining us today for this briefing to discuss a critically important case currently before the Supreme Court, Goldman Sachs versus the Arkansas Teachers Retirement System. With oral arguments in the case scheduled to begin March 29th, we wanted to highlight just how significant this case is for investor protection and market integrity. At stake in this case is whether investors who are the victims of a particular type of securities fraud, in which companies use false and misleading statements to maintain an inflated stock price, will have to clear additional, likely insurmountable hurdles to get those claims into court. The case has its roots in the 2008 financial crisis, when Goldman was earning billions of dollars packaging and selling a particularly complex type of mortgage-backed security called CDOs. What Goldman didn't tell its customers or its investors was that some of those CDOs were being loaded up with mortgages that were destined to fail so that other more favored customers could profit by betting against them. All of this has been well established, including by the Securities and Exchange Commission and the Department of Justice in separate enforcement actions based on this conduct. But while investors in those CDOs have received at least some modest compensation for their losses, they were not the only victims. This case involves the investors not in CDOs, but in Goldman's stock. So during this period in which it was profiting handsomely by playing customers off against each other, Goldman was simultaneously making public statements claiming that it had rigorous controls over conflicts of interest in place so that its customers' interests always came first. Investors in this case are arguing that those clearly false statements serve to maintain an artificially inflated stock price, a stock price that would have been lower if the truth were not being concealed. And that having bought at that inflated price, they suffered financial harm when the truth about Goldman's conduct emerged and the price of the stock dropped. Goldman, meanwhile, is arguing that those statements are simply too generic to have had any impact on the price of the stock. If Goldman's arguments were to prevail, if the court were to rule that out such cases, as long as the statements were in the view of the court sufficiently general, or if it were to require investors to essentially prove their case at the class certification phase, it would become much harder for investors and potentially for the SEC to hold companies accountable for this type of securities fraud. We at CFA believe that would have a harmful impact on investors and on market integrity. We are not alone. The experts who will be speaking to you today, in their varied backgrounds and expertise, demonstrate the broad range of interests in individuals that are deeply concerned about the potential implications of this case. So without further delay, let me introduce them. Our first speaker will be Kevin Lindahl, General Counsel and Deputy Executive Director with the Fire and Police Pension Association of Colorado. Second will be Lynn Turner, former Chief Accountant with the U.S. Securities and Exchange Commission. Third, Matthew Kane, former financial economist with the Securities and Exchange Commission and currently Senior Fellow with Berkeley Law School. And fourth, Andrew Park, a Senior Policy Analyst with Americans for Financial Reform Education Fund. So let's begin with our first speaker, Kevin Lindahl, General Counsel and Deputy Executive Director of the Fire and Police Pension Association of Colorado. Kevin?
Good morning. Thank you for taking the time today to listen to our concerns regarding this Goldman Sachs case. The Fire and Police Pension Association of Colorado Its mission is to provide financial security in retirement for over 20,000 firefighters and police officers in Colorado. As fiduciaries of the assets of the plans that pay those benefits, we have to ensure that once we collect the contributions made by both the members and the employers of our participants, that those funds, those assets can be invested in the US and international markets. We, as fiduciaries, manage nearly $7 billion in assets to pay those promises that are made to firefighters and police officers over the course of their career to ensure that they have financial security in their retirement. This case is critical to us because as participants in the marketplace for investments, we have an obligation to ensure that those markets have integrity. And one of the tools that we have currently available to us to do that is to hold boards of directors and corporations and officers of corporations accountable when they commit fraud, when they say false things to the market, and when they commit other malfeasance in office. And when those actions cause a loss to the shareholders, FPPA has been aggressive about holding those folks accountable. And we are concerned in this particular case that one of the tools that we have available to hold those individuals and those corporations accountable could be removed from our arsenal of ways that we can make sure that the markets act with integrity. And this is important because just even the threat that this tool is available to us causes corporations and those running corporations to act with integrity and to not make false statements and to be very careful about what they're telling their shareholders and potential shareholders when they're communicating publicly about the operations of their corporations. Thank you.
Thank you, Kevin. Again, that was Kevin Lindahl, General Counsel and Deputy Executive Director with the Fire and Police Pension Association of Colorado. Let's go now to our next speaker, Lynn Turner, former Chief Accountant with the U.S. Securities and Exchange Commission. Lynn?
Thanks, Barb. And again, thanks to all the reporters and journalists who are on the conference as well. This is a very important issue. It runs to whether or not when you're investing your money into the markets, you can trust them. You can have confidence that they're giving you accurate, complete information, and they're not omitting any facts. All too often, we've seen where management has put out false facts to hype their stock. I saw that time and time again at the commission. It's very important in the Goldman case. Goldman was considered the gold standard of the investment banking industry. I was a senior executive in a large international semiconductor manufacturing company. And as we got ready for an initial public offering, we chose Goldman over 7 other firms because of the fact they were the gold standard. They were considered to be the firm who did it best and did it right. And yet, as we found in this case, through the disclosures of what's often referred to as the shitty little deal, quite frankly, the Abacus transaction, we found out that instead of being the gold standard, they ended up in business class cases as an unethical type conduct. And now Goldman is saying they should be let off the hook because the statements they made in their filing are too generic to have resulted in a loss of the stock. But that's not true. The stock did drop dramatically when all the findings and the conflicts involved in the Abacus transaction came out. Goldman turned around and agreed to over a $500 million settlement at that point in time. If you agree to that big a settlement, and it's not because these things are not important and not material. They talked about they had the best controls in place to prevent conflicts. They had, and to use their words, we have extensive procedures and controls. And as we all know, controls was important enough that Congress required disclosure of these type of controls when they did Sachs. So it's vitally important information. It did impact the stock. Now trying to get out from being held accountable for unethical conduct involving conflicts. And this has not only been the only one. They have subsequently had a problem with their Malaysian bond deal that cost them billions of dollars and again impacted investors. So the notion that these statements are generic, these statements that Goldman picked to try to again convey the picture that they were the gold standard to those who chose to invest in their company. And that would have been a very material piece of information versus saying, we ain't got controls in place. We're not telling you about all the conflicts, which is what reality was. And so 10 years after this all came to light, they're still trying to keep investors from having their day in court. And this could be very damaging to the ability of the SEC to bring enforcement actions, in that the SEC often brings cases based upon the fact that executives have hyped their stock to keep it up there. And now Goldman is saying, oh, but we shouldn't allow that to be a basis for a lawsuit by the shareholders of the company. If the Supreme Court rules that way, it will destroy your ability to have confidence in the statements made by management and in the information you get that you have to make informed business and investment decisions.
Thanks, Lynn. Again, that was Lynn Turner, former chief accountant with the U.S. Securities and Exchange Commission. Let's go to our next speaker, Matthew Kane, former financial economist with the Securities and Exchange Commission and senior fellow at Berkeley Law School. Matt?
Thank you for having me on today to discuss this very important case. I just want to start by emphasizing that the capital markets in the United States are among the most well-developed and sophisticated in the world. This is not due to luck or random chance. Academic research has clearly shown that market development is maintained by a robust regulatory environment that fosters investor protection. This market integrity correlates directly with company valuations and thus the returns that investors, including individuals, can expect from putting their hard-earned money to work as shareholders. The SEC plays an outsized role in ensuring market integrity, including by holding company executives accountable for their public misrepresentations. But the reality is that the SEC is resource constrained. They simply don't have the ability to monitor all information at all times. And as a result, the SEC relies on shareholder lawsuits like this one to assist with the enforcement of integrity in our financial markets. The allegations in this case involving Goldman Sachs are quite serious. And as Lynn Turner just pointed out, in a related case, Goldman paid the largest penalty in SEC history at that time, over $500 million. Some people have argued that allowing cases like this to proceed will open the floodgates to frivolous litigation. Personally, I find it ironic that anyone could equate conduct that resulted in the largest SEC penalty ever with frivolous litigation. Financial economists employ rigorous tools to measure the value of corrective information when it's publicly revealed, which relates back to purported company misrepresentations. If a company's stock price drops for other reasons that are unrelated to an alleged fraud, these tools are capable of making such a determination. So to put it simply, frivolous lawsuits can and are very quickly dismissed. In summary, Shareholder lawsuits are a vital component of investor protection, and it's imperative that the Supreme Court not take any actions that would handicap this important check on corporate wrongdoing. Thank you very much. I appreciate it.
Great. Thanks, Matt. Again, that was Matthew Kane, former financial economist with the U.S. Securities and Exchange Commission and currently a senior fellow with Berkeley Law School. Let's go now to our final speaker, Andrew Park, a senior policy analyst with Americans for Financial Reform Education Fund. Andrew?
Great. Thank you, Barb. I wanted to offer some background today about some of the problems that we saw with the subprime mortgage loans and also the CDOs that were made before 2008. And despite the claims of the contrary, the clear and serious conflicts of interest that were part of the way Goldman Sachs did business in both of those realms. Many of you may recall how fraudulently underwritten subprime mortgages were packaged into securitizations called collateralized debt obligations, or CDOs. In one particularly notable case, that's at the heart of this, we're talking about the Abacus CDO back in 2007. And so Goldman offered that CDO to its clients while failing to disclose the fact that in that case, a hedge fund, Paulson and Company, had actually selected many of those loans, and also that they were then betting on the CDO failing. So Goldman in this case had pitched this as a good deal to their clients while knowing, in fact, that it was actually going to lose money. And we find actually that was the case. By October 2007, nearly 100% of the CDO's assets were downgraded by the rating agencies. Goldman ultimately, as others mentioned before, settled with the SEC in July 2010 for misleading investors in the Abacus CDO, for nearly $500 million. So what ultimately is at stake in this issue is whether Goldman Sachs will be held responsible by investors for those actions leading up to the financial crisis. And more importantly, whether companies going forward will be dissuaded from engaging in that same kind of conduct because of the potential consequences. I like to point out that in the years following the financial crisis, the Senate Permanent Subcommittee on Investigations actually uncovered several emails from a number of Goldman's employees going as far as 2006, where they would actually exchange in emails warning about the problems in the subprime mortgage market and also how they were being securitized. And this is all happening while they continue to sell these products with little regard to their customers' best interests. I'd like to point out one startling email from October 12, 2007, where a Goldman salesperson started to express remorse about the CDOs they had just sold their clients, and also, would soon lead to large losses. I will quote, "The damage this has done to our franchise is significant," from what the salesperson had been saying. And he had actually gone on to estimate that those clients over the next ensuing months had lost as much as $1 billion. Funny enough, that same salesperson would later complain to his team in other emails that the Senate subcommittee had pulled that they were not being paid as much as they should be because, and I quote again, behavior was not consistent with the money it ended up making or saving the firm. And I've heard the payout was not consistent. So what Goldman is trying to argue here is that the generic statements it's made to its shareholders related to conflicts of interest were not specific enough, and therefore they can't be held liable for artificially propping up the price of their stock. But as you just heard, those emails and many others like them show that Goldman's employees were well aware of the poor quality of the products that they were selling. And on top of that, they felt uneasy about what they were doing. Again, this is even as Goldman was claiming that they were putting their customers' interests first. And I'll add this final detail. In 2006 and 2007, Goldman's insiders wound up selling over $100 million in stock ahead of the ensuing financial crisis. That's double the amount of sales that we saw in 2005. And still, when we look at post-2008, it is still well above the average pace of sales in those following years. Goldman's executives, certainly sensing the trouble ahead, clearly rushed to sell their shares, and this also left the the rest of their shareholders to contend with the ensuing losses. Again, I point all this out because many pieces of the financial market are fraught with asymmetric information, usually where the bank has much more visibility than its clients and its shareholders. If clients can't hold financial institutions accountable around their policies and procedures in place to prevent conflicts of interest, then how can there be any accountability or any sort of investor protections?
Thanks, Andrew. Again, that was Andrew Park, Senior Policy Analyst with Americans for Financial Reform Education Fund. And I'll now turn it back over to Max to lead us through the Q&A portion of today's events. Max?
Thank you. And as Barb just said, that this has taken us to the Q&A portion of the call. If you wish to ask a question, use the raise your hand function and your line will be unmuted when it's your turn to ask a question. As a reminder, the Q&A period is for reporters only. If you're having any issues with your own audio or the raise your hand function, you can use the text-based Q&A box and we'll do our best to get to all those questions. And now joining us for the Q&A period are two additional speakers, Attorney Daniel P. Chiplock, partner at Leaf, Cabraser, Eman, and Bernstein, and Attorney Stephen Miller, investment counsel, the Fire and Police Pension Association of Colorado. And looks like we don't have any queued up. While we're waiting for our first question to come in, just want to say that if you need to connect with any of the speakers you're hearing from today, or to get more info, you can contact Max Carlin, 703-276-3255, again, 703-276-3255. And we are recording this news event, and that's going to be online later today. So let's see. Our first question is coming in from Mark Schaaf, Investment News. And Mark, please unmute yourself. It's your turn to speak.
Yes, hi. Can everyone hear me?
We can.
Yep.
Thank you for holding today's event. This case is one I hadn't been following closely, so thank you for bringing me up to speed. And I'm wondering, how does the addition of Justice Amy Coney Barrett to the court, making it a 6-3 conservative majority, affect, do you think, the court's approach to this case? Is it going to be even more difficult for you to see a decision that you'd like to see, given that the conservative majority is now even stronger?
So I'll jump in first and let others. I am not, a Supreme Court expert, but I think, honesty shouldn't be a liberal versus conservative issue. The securities laws, which are based on transparency and reliability of information, are fundamental to the economic success of this country. So we would certainly think having appropriate, protections in place to ensure the reliability of the statements that corporations and their executives make would be something that ought to unite people across party lines. I'm not naive. That has not, well, that is theoretically a logical statement. It hasn't always proved out, in reality. So, I'm not going to predict how the court will decide it. And I'm not going to pretend that this is, an easy slam dunk. If we thought that, we probably wouldn't be having today's event, right? But I do think that the fundamental principles here aren't ones that should be controversial in a sane world. Did anyone else want to join in?
I would, Barb, this is Lynn. I would add that this case has been down at the lower courts at the Southern District in New York, as well as in the appellate court for some period of time, for some years now. And in fact, Goldman appealed the initial decision of the judge who certified the class. And when they appealed up to the appellate court initially remanded the case back down to the judge, saying he had not considered all the facts, in particular a key case, legal case called Basic versus Levinson, in which it requires that there be a preponderance of the evidence to certify a class. And so it got sent back down. The judge actually went through additional hearings, additional evidential hearings, and then reconsidered the case and again certified it, and it again got appealed back up to the appellate court. On the second time, the appellate court did say the judge had considered all the evidence, had considered that investors had suffered a loss, and the appellate court then permitted and agreed that the class could be certified and that the case could move forward. I am concerned that obviously at least some of the justices on the Supreme Court have viewed part of that, those findings as flawed, or otherwise we wouldn't have certain they wouldn't be listening to the case. So I am very concerned where this particular court might come out. I do agree with Barb that the basic fundamental issue here is one of truth. And it's not really where it's generic or not. These are very important statements that were made. That's noted in the appellate court decision. In fact, the appellate court lists out every one of these key disclosures that Goldman made in their opinions. So the judges carefully considered that and considered whether they could have impacted the loss. And so I am very nervous. And if they do decide to rule in Goldman's favor, I think the SEC's, it would need to have some type of congressional action, because the SEC enforcement abilities would take a huge, huge hit.
So let me just throw in one more point on something Lynn just said, because Mark, you of all people who've spent almost as much time on Reg BI as I have, should know just how significant these statements are. You know, if statements that we always put our customers first, if statements that we have strong controls in place to address conflicts of interest are just generic, if they're just puffery, then the entire foundation of regulation best interest is just generic and puffery. And then I think that would mean that the SEC would essentially have to go back and completely rewrite those rules. So I think, as I said, you of all people should understand just what significance our regulations give to statements like these. As Lynn mentioned, they're central. The statements about controls are central to the Sarbanes-Oxley Act. You know, these are built into our securities laws. And if we can just dismiss them as generic, something that no reasonable investor would rely on, that has really far-reaching implications beyond this case.
Let's go to our next question. It comes from Greg Storr at Bloomberg. And Greg, go ahead and unmute your Zoom.
Hi, just wondering if somebody could comment on the Biden administration brief. I'm wondering if you see that as more of a glass half empty or glass half full for your side.
So again, I'll defer to the attorneys if they want to jump in, but I would say one of the issues that's at stake here, you know, it's easy to get lost in sort of the technicalities on this case. One of the cases at issue here is just how far the investors have to go to prove their case at this class certification stage. And, you know, do they just have to essentially produce evidence, or do they have to persuade the court of the validity of, of their price impact arguments? And I think the Biden administration brief is quite helpful on that point of, saying that they should not, in fact, have to prove the merits of their case just to get the class certified. So I'll ask if either of the lawyers want to weigh in, or anyone else wants to weigh in with a further answer to that.
Sure, I'd be happy to do that. I think, as Barbara just pointed out, the main question here is whether materiality needs to actually be proven at the class certification stage by plaintiffs in order to maintain a securities class action. What Goldman has tried to do here is they've presented a ruse. They've said that justices and judges will have no choice but to let these cases go forward in the future if defendants like Goldman aren't permitted to present arguments that what they said simply didn't matter and couldn't have mattered to investors when making their decisions. But what the reality of this case proves is that it's a very highly context-specific determination whether a defendant's statements or failures to disclose information actually had or could have had an impact on investors' decisions. And that's not to be taken lightly. It's not something to be overruled by a judge's mere intuition or common sense about what constitutes a purely generic statement. It's a highly contextualized, fact-specific determination. And in this case, we had multiple experts battling it out on more than one occasion at the trial court stage, as Lynn was pointing out earlier, and reviewed by the Second Circuit. This case has been litigated very heavily, and the judges have been very careful in weighing the evidence and the expert testimony presented to them on this very important question. Goldman's argument at this point is basically, you know what, throw all that out the window. If something is purely generic, it's purely generic and nothing else matters. Well, that's not the law. And I would also add, and the Biden brief recognizes this, as do many of the other amicus briefs, there are other avenues for courts to dismiss cases when they feel that the claims are purely frivolous or that the statements were so immaterial as to not have been able to have had any impact on investors' decisions. They have that opportunity at the motion to dismiss stage, which is pretty early on in the litigation. In the Goldman case, plaintiffs got past that stage. Goldman had that chance. They made that argument. The judge determined it should go forward. Goldman will have another chance to make that argument at the summary judgment phase. Class certification is not the appropriate time to have that argument, because at class certification, what you are deciding is whether questions bear on the entire class or not. And in this case, whether or not the statements were material to the class is obviously a question that applies to the class overall. It's not something that's going to be individual investor specific. So that's why we feel, the Biden brief and others have the law right when they talk about this issue and the importance of separating out the court's functions at different points in the litigation.
I would just like to add.
Go ahead.
Okay. I would just like to add that when you're handling these cases, it's critical to understand the different stages. And we're at a very preliminary stage in this case with class certification. And what Goldman would suggest is that we've got to be able to prove our case at class certification. And there are other opportunities for it under our traditional process for these cases to prove the case. But we haven't had, in this case, the benefit of discovery yet. And oftentimes that discovery is really necessary in order to prove the case. And so the Biden brief certainly supports the current process, which is what we're arguing is appropriate for these cases.
Great. Thanks, Kevin. And for anyone listening by phone, that was Kevin Lindahl at FPPA of Colorado. It looks like we've got a question in the Q&A box. It comes from Henry Engler at Reuters. He asks, what type of damages are the plaintiffs seeking in the case?
So again, I'll appeal to the attorneys. I'll have to admit that I've been so focused on the policy implications of this case that I don't even know off of the top of my head what the damages being sought are. Is that something you can answer, Daniel?
I can speak to that, I guess, just as a general matter. I'm not representing the plaintiffs in this case, but I will say that it is probably too early. Usually, the actual quantification of damages does not happen at class certification. That happens at a later point, during the merits phase of the trial. I do note from having read the respondent's brief that they are not claiming $13 billion in damages, which is what Goldman, I think, alleged or contended in their petitioner's brief. The damages will be something less than that. But apart from that, I don't know the exact quantum. You'd have to ask counsel for the respondent.
This is Matt Kane. I'll echo what Daniel just said, which is that the calculation of damages occurs at the merits and loss causation stage of the case, which comes much later than the class certification of the case, after discovery has taken place, after calculations have been performed by the financial economists of the actual harm to investors. So it's too early to try to put a number on that at this point in time.
All right. And just as a reminder, we do want to make sure that all the reporters on the line have a chance to pose their questions. So if you do wish to ask a question, take advantage, use the raise your hand function, and we'll unmute your line when it's your turn to ask a question. And also as a reminder, we do have the Q&A box if you're having any audio issues whatsoever. Let's see. I'm not seeing any further questions at the moment. Barb, do you want to offer any kind of closing thoughts or remarks?
Sure. What I would just say is, as we've seen from recent events around GameStop and Robinhood, the public's faith in the integrity of our capital markets is hanging by a thread. We have all too many people who are convinced that the markets are rigged against them. And the Supreme Court has an opportunity to send a clear message that words matter, that honesty matters, and that no company is too big or too powerful to be held accountable. And we certainly hope that that is what they do when they decide this case this year. Thanks. And thanks to everyone for joining us.
Sorry, it was muted. To connect with any of the speakers you've heard from today or to get more info, just contact Max Carlin at 703-276-3255. We are going to have a recording of this news event available online later today. So again, contact Max if you're having trouble finding that. We do thank you for joining this media briefing, and that